My lord, this application, my lord, is for
Today's not a company day.
I know, my lord, because
Mention tomorrow,
uh,
2 p.m. Company.
the matter is running in the list.
Ah.
It's an application of 2015.
Huh?
And it's an application of 2015.
Ah,
So the problem that, my lord, we are running is that the list is being called every day, but it's not reaching there yet. And
ah.
because it has been pending for some time, my lord, we have had to carry out 2 or 3 substitutions because, my lord, the applicants are, my lord, dying. So
Okay,
that's why
let us see tomorrow. Let it come tomorrow.
well, then
How
I'll
far
come.
the court will go, then we'll see it.
Grateful, my lord.
Yes.
Item number 1.
Not today.
Chips, item number 1 and 2, I appear for the plaintiffs. I'm led by Mr. Saha and Mr. Sen.
Well, I'm there, my lord. I'm ready to go carry on.
क्या हुआ? System क्या हुआ?
Item number 1, I am appearing for the plaintiff.
My lord, I am there, my lord. My lord, I am there, my lord, in item number 1, if lordship permits, my lord. This is for plaint presentation. My lord, there was some, this is, my lord, a suit for, my lord, declaration and injunction, where there is some urgency, my lord. Kindly, my lord, takes, my lord, the paragraphs 24 and 25 of the plaint, my lord, at page 11.
Yes.
My lord, I was inducted as a tenant, my lord, in respect of this property under an agreement of 25th of January 1988. My lord, 2 clauses I would, my lord, show, my lord. And then, my lord, I'll come back to the urgency. Page 39, lordship kindly takes, my lord, clause 2G, which provides, my lord, a right for subletting.
Page 39.
Page 39, my lord.
Yes. Clause.
My lord, 2G. Second line, my lord. The
Yes.
tenant shall be entitled to sublet the tenanted premises in whole with a further right to subtenancy on such rent and on such terms and conditions as the tenant deems fit, provided, however, tenant shall always remain liable to make payment of the rent. Malad, this is one clause. Lordship will kindly come to page 41, subclause E. Only, my lord, the right of termination which is provided under the agreement. In the event of any willful breach of the terms and conditions herein contained and on the part of the tenant to be observed and performed, the tenant shall be held liable for compensation or damages and or termination of the tenancy if the same are lawfully proved. So, my lord, they have to, my lord, first establish willful breach, and, my lord, they have to lawfully prove that, my lord, there has been a willful breach. My lord, these conditions were not satisfied, yet, my lord, a suit was filed against my client in the, my lord, city civil court. Now, my lord, in that suit, my lord, an order was passed at page 47, if your lordship come. Page 47.
Yes.
My lord, last 7-8 lines, starting with accordingly the plaintiff. Lordship has found that.
Yes, accordingly the plaintiff.
Plaintiff has filed the suit for declaration and plaintiff petitioner is apprehending that defendant respondent may at any point of time sublease the property to any third party or to assign or to sell the same to any third party. That is why the plaintiff petitioner has filed an application for injunction and moved for ad interim injunction so that defendant respondent firm may be restrained from assigning, selling or creating third party interest in respect of the suit property. Now, my lord, this order was passed in their favor.
Where
by
is the
the
complete order?
I'm sorry, my lord.
Where is the complete order? Where is the continue page?
Oh, there is one page, my lord. In my brief also that page is missing.
The
My lord,
continue.
there is another place where, my lord, this, my lord, order is there. My lord, I'll show it from there. Because we had preferred an appeal. Well, I'll tell you, lordship, what had happened, my lord, before the city court, my lord, the city court had passed an order of injunction, restraining me from assigning subletting. Now, my lord, we come up before this court. The division bench clarifies, and lordship will find the division bench order at page 78. My lord, kindly comes to page 78, paragraph 2. we modify the impugned order to the extent that the appellant shall not act in derogation of the agreement dated 25 January 1988 till disposal of the injunction application.
Page
My
70?
lord, 78, my lord, 78.
No, there. इसका second volume का है? Second volume?
Well, this should be in one volume only because it's within 150 pages, possibly.
No, this, which,
Plaint, my lord, plaint.
plaint, it is the first, item number 1 though,
Yes, my lord.
CS 142.
My lord, this is Mohata Projects LLP.
Mohta project, it is, your plaint contains the first volume till 77, page 77, annexure A2. Thereafter, कहाँ है? Nothing is there.
Arumita, you're there.
No, only 77 page is there. Last page is 77.
And my lord's records do not have the second volume or page 78. I suppose, my lord, there's no one in court also, my lord, to get any assistance from there, my lord, from my end, my lord.
No, there is no second volume is not here. The second copy is there. Plain second copy is there. That is also 77, page 77.
My lord, may I show from the pleading ones?
No, but there is the document. क्या आया नहीं?
Paragraph 11 of the plaint, I have pleaded this order.
Paragraph 11.
Yes, my lord. Page 7, paragraph 11 of the plaint, I had pleaded this order. In the said appeal being FMAT so-and-so, an order dated 20th August 25 was passed by which plaintiff was directed not to act in derogation of the agreement dated 25th January 1988. So, my lord, agreement provided that I can sublet. The trial court passed an order of injunction against me. I got a clarification from the division bench that if I act in terms of the agreement, it was clarified that plaintiff was directed not to act in derogation of the agreement. So, my lord, I could have, my lord, sublet. I have sublet. Now, what has happened is, my lord, kindly now comes to, my lord, paragraph 24. Immediately after the order of 20th of August, on 22nd August, I get a notice of eviction. Now, this notice of eviction is contrary to the agreement provision where they have to, my lord, establish willful breach of the terms and conditions. That is why, my lord, the urgency today, because they have sent persons to, my lord, remove me from position. Plaintiff contemplates urgent interim relief in the suit by the notice of 22nd August received by the plaintiff on August 25. The defendant threatened the plaintiff to evict the same on expiry of 15 days from the receipt of the notice. 15 days expired on September 8, 25. Defendant was always aware that the plaintiff had subleased the premises to a third party and business operation of such third party is being carried out in the premises. On or about 13 September, defendant sent its men, agents and hooligans at the premises who entered into the premises and attempted to take forceful possession of the same. Immediately thereafter, on 15 September, plaintiff lodged a complaint with the officer in charge of the Shakespeare Shoroni police station complaining about the untoward incident at the said premises. My lord, the copy of the complaint is also annexed, but my lord, after page 77, it's there. I don't know, my lord, since it's not there, I can't, my lord, draw my lord's attention to the complaint. Then para 25, there exists extreme urgency in the matter. There is every possibility that unless restrained forthwith, defendant or its main agent shall again visit the premises and take forceful possession thereof. Defendant had initially attempted to disrupt the peaceful possession of the plaintiff and to otherwise interfere with the lawful rights of the plaintiff as recorded in the agreement of 25th January 88 by instituting the frivolous suit. However, now the defendant has taken extreme steps which are otherwise illegal for the purpose of evicting the plaintiff. My lord, it is in these circumstances, my lord, I am instituting this suit and seeking, my lord, dispensation of the, my lord, mandatory, my lord, pre-institution mediation, because I would be pressing for, my lord, urgent interim orders to protect possession, my lord.
So already there is a suit against you. Why you are not moved before the city civil court?
My lord, this is I have advised the client to, my lord, the plaintiff here to file application because it's a commercial dispute, my lord. We had taken this as a ground also. The property is actually being used for trade or commerce. It's a, my lord, jewelry store, my lord, which is being run. my lord, presently. So, my lord, city civil court otherwise will not have jurisdiction. And my lord, that is why, my lord, we have come here. And there, my lord, I am not the, my lord, plaintiff, I am the defendant. So, my lord, I needed, my lord, protection, my lord, from the court. And that is why now, if your lordship sees the reliefs which I have claimed, my lord, for the time being, my lord, the perpetual injunction, prayer D and E, in terms thereof, I would be seeking, my lord, some ad interim order, if lordship is kind enough to allow the dispensation, my lord, under 12A. And I will definitely, my lord, ensure that the entire records are there, my lord. Today is a
Where is
difficult day.
the- Where is the notice of 24th of August?
My lord,
22nd,
that is
where is the notice?
22nd of August, notice is, my lord, page 79. I can, my lord, read it for your lordship. Lordship will not be having that because lordship said 77 is the last page. My lord, I will read it out for your lordship. It's a notice for eviction from one shop room, showroom, together with toilet covering an area so and so. Under instructions from and on behalf of my client, I do hereby address you as follows. This is, my lord, defendant's advocate's letter. Please note that you are holding possession of one shop room together with a toilet covering an area of such and such on the ground floor of premises number 20 Shakespeare Sharoni, Kolkata, as per an agreement between my client and you,
Okay,
dated 20.
but Mr. Make arrangement, where is another, either the second volume or the document, unless and
Well,
until
I shall ensure, my lord, it is there tomorrow. Kindly gives me the dispensation so that I can move the application tomorrow. If the records are not there, I understand I cannot move it, my lord.
not there, how the 12A can be granted? Because your case is based on the that notice. Notice is not before the court, only the pleading.
Kindly, for today, kindly takes, my lord, note of the pleading, my lord. Kindly comes back to the plaint, my lord. The notice I have pleaded, my lord, at paragraph 13, page 7. Lordship will find, my lord, the
Notice is not here.
my advocate on record also could not reach, my lord, because of the waterlogging at his place, my lord. This is the difficulty today, my lord. But if the, my lord,
इसका क्या हुआ? फाइलिंग में कुछ क्यों इसका एक ही आया? ऑर्डर रिकॉर्ड क्यों बेचते हैं डिपार्टमेंट? कोई अच्छा कोई एआरसीआर भी नहीं है. My staffs are also not there, Mr. Who will
my lord,
take?
my lord, lordship understands we only have 3 more days, my lord. Friday, it's very difficult, my lord.
What
2
can
more.
be done?
Kindly, my lord, gives me, my lord, the dispensation, my lord. If the records are not in order, tomorrow, my lord, lordship will, my lord, not pass any order on my application. But today, my lord, as a special case, kindly allows the dispensation so that at least I can attempt to, my lord, bring the records and move the application tomorrow.
Somebody should be here to take dictation. कोई नहीं.
My lord, if an endorsement can be given on the fiat of the plaint, my lord, that will also, my lord, possibly help my cause. Tomorrow we can regularize the things.
Okay, come tomorrow. Come tomorrow.
My lord,
Because-
may I only pray for may I only pray for this, at least if your lordship indicates to your lordship's officer, whoever is present in court today, that at least the GA should also come tomorrow, my lord.
Let the instructed. Let the record bring tomorrow. Because in the department also nobody is there.
No, I understand, my lord. It's a difficult day today, my lord, for all of us. My lord, I'll come back tomorrow, my lord, and I'll ensure that the entire records are there.
Fix tomorrow. Kal आने दो. Yes. Next.
My lord, I am very prepared for the plaintiff. There is extreme urgency, my lord. What happened in this matter, my lord? This is my lord, plaintiffs, the original original parents,
Yes, sir.
the original plaintiffs are father, and the generation wise the business. What happened in the my lord? And the defendant was the employee with the salary of 18,000. What happened, my lord? She desired to make a panna.
What do you want?
Money should I have.
At present, what is your prayer? At present,
At present, dispensation of the 12A.
where is the see the prayer? Where is the prayer for dispensation? Neither in the prayer portion nor in the concise statement. Can you see?
My lord,
Where is that?
24, my lord. Can you look at?
24 is is your statement. Where is the prayer? Where is the prayer?
there, whatever my lord, I'm submitting, I kindly dispense with.
Huh?
Kindly dispense. I submit it.
Not the- First, you have to rectify the defects, sir. I am giving you. Nobody is there. New gentleman. I am
My lord,
giving-
I am the advocate on record, my lord, in this matter, my lord.
So,
There is huge emergency, my lord. I could not reach court, my lord.
correct, madam, but there is no prayer for leave. You made an averment in paragraph 24, but where is the prayer in the prayer portion for leave?
24 is the praying for leave. 24 is
Prayer.
the praying for leave, my lord.
24 is a prayer.
No, my lord, that is the pleading, but that is the prayer for leave.
Okay, if I consider that is the prayer, kindly come to the concise statement. Concise statement, where is the leave?
Statement.
Where is the prayer for leave?
Liberty be given to
My lord, I will amend it. I will correct the concise statement, my lord, tomorrow.
liberty given to put the prayer here and now.
Yes, correct.
Here and now, my lord. But tomorrow, my lord.
Not today. Leave
It is
granted.
enough.
Leave granted to add the prayer in the concise and prayer portion.
My
My
lord,
lord, kindly leave may be granted, my lord, to
Yes.
appear the GA with this with the matter, my lord. With
Yes,
this, yes.
Leave is granted. Let the prayer be corrected. It will come tomorrow. Next.
Grateful, my lord. Grateful.
my lord, I have granted here and now.
Third, item 9, my lord, is my application.
Hmm.
Now, this is only one application.
I'm
is
opposing the
appearing
application.
for injunction. But before I start, my lord, I must indicate there is an order of the division bench for not as my plaint, my application. But there is an order of the division bench by saying that the suit should not be transferred to commercial. Now that order is page 106. The Honorable Single Judge's order is page 103. The appeal court's order is 106. Now, when we went to the department to file this application, by the time we found the department has already converted the suit to a commercial suit.
Without prejudice to contention, the respondent shall not take any steps with regard to it till the disposal of the appeal. Respondent shall proceed with the said application in the suit after the decision of this court on the matter.
No, page 107, the first line.
It is 107.
Page
First line.
107, the first line.
First line.
Till disposal of the appeal, the suit shall not be transferred to the yes. What about the appeal now?
Appeal is still pending.
Pending, and Lordship, this suit should appear in the non-commercial list, and therefore this application should be
The
listed.
difficulty is, my lord sees the back sheet. It was initially.
Who has filed this application?
We have filed the application. We have filed the application, or she will see the reverse, absolute the back sheet of the application. It was intended to be moved before the non-commercial court. Now
But
we find the department has forced us to file here because in the meantime, department has converted to a commercial matter.
Lordship will record that in view of the division bench order, let the suit appear in the non-commercial.
Yes. Because then I can't move this application here before the commercial bench.
And Milord, also a direction that so far as this change of suit is concerned, that should be restored. Because that probably has ignored the notice of the department.
Then again, this mistake will happen in the department.
Where is the where the suit filed? It is a commercial division or this?
No, it was a non-commercial division.
Filed in the non-commercial division. We took out 2 applications for revocation, and Milord, those applications were dismissed. But the court, Milord, while dismissing these applications, suo motu found that the dispute pertains to commercial dispute, and thereafter transferred it to a commercial division. We went up in appeal, and before the Court of Appeal, Milord, we contended that the suit was not a commercial dispute.
Where is the order of this court?
Page 89. It starts at page 89. The ordering portion Well, it will find at 103.
Paragraph 20.
Paragraph 20.
But nobody is there.
Against this Milon, an appeal was preferred.
To
and
whom
the
I
court
can
of-
to whom I declare the order.
Oh,
There is no recording officer.
Milord keeps it tomorrow, Milord, as to be mentioned. My learned friend will take appropriate steps to have it recorded.
That can be. Tomorrow has to be mentioned, Milord. That can be. Because I have another application also, which is GA6. That will also appear and we get it transferred to the non-commercial division.
This application is filed for grant of injunction. करो खाली appearing वाला को रखो.
The court also got silent.
The court's
When the court got muted. Court is also muted.
কিছু শুনতে পাওয়া না।
সাইলেন্ট করতে বলে তো সব বন্ধ করে দিই।
Commercial division.
Sub muted.
GA number 2 of 2015. This court, by an order dated 5th March 2021, had transferred the suit being CS 250 of 2015 from non-commercial division to commercial division. And accordingly, the department has assigned the commercial number. In the meantime, the plaintiff had preferred an appeal before the appellate court against the order dated.
Not the plaintiff, the defendant number 2.
Defendant number 2 had preferred an appeal before the against the order dated 5th March 2021. Earlier, who has filed a defendant filed an application?
Yes.
That was allowed.
Yes. No, the application was dismissed. Defendant number 2 filed rejection of plaint.
It is actually the plaintiff had filed before the non-commercial division. Full stop. In the said suit, defendant has filed defendant number
2.
Defendant number 2 has filed an application for rejection of the plaint, dismissal of the suit, and by an order dated 5th March 2021, this court has transferred the suit from non-commercial division to commercial division, and accordingly, the department has assigned the commercial suit number being CS Com 66 of 2024. In the meantime, the defendant had preferred an appeal against the order dated 5th March 2021, being APOT 52 of 2021. By an order dated 12th of July 2021, the appellate court had passed the following order. It's inverted comma, till the disposal, italic, inverted comma, italic. Till the disposal of this appeals, comma, the suit shall not be transferred to the commercial division as a commercial cause. Now the Plaintiff has filed the present application.
Yes, my lord. Yes.
Plaintiff has filed the present application being GA Com 5 of 2025, praying for interim order. Counsel for the parties submits that by an order that in terms of the order passed by the appellate court dated
12th
Page
July.
106.
12th of July 2021. The suit along with this application, that is GA Com 5 of 2025, is to be placed before the non-commercial division. As till date the appeal being APOT number
52 of 2021 and 53 of 2021.
In view of the above, the department is directed to reassign the number as a non-commercial number in the suit as non-commercial suit as well as in the present application, and to place before the Honorable Court having determination. Let the department is directed to carry out the aforesaid order within a week. There's an urgency after vacation.
It can be after vacation. Can be after.
A week
No,
after.
only one thing, my lord. I have taken out another application which is GS6, which is by the master summon for addition of party. So, if lordship's pleasure to record that any other applications we also convert it.
Clear that the department, it is made clear that if any parties file any application in connection with the present suit being CS Com 66 of 2024 be transferred to the commercial and non-commercial division in terms of the order passed by the Honorable Division Bench dated 12th of July 2020.
Com should remain.
After the order passed, after the disposal of the till the disposal of the appeal.
Oblige.
Next.
Sure. Deeply obliged.
Item number 10.
My lord, 11:30 a.m. matter is, your lordship had been, I do not know, my lord, Mr. Shah was also there. He was leading me.
Fine, 11:30 concert.
The matter yesterday, my lord, Mr. Probal Mukherjee had concluded his submission on that matter. So it is kept today.
12:30 है क्या?
11.
Other, where is Mr. Shah?
Mr. Shah was leading me. I do not know whether the other side is there or not.
Yeah, nobody's here.
Nobody.
Either in the online. Where is it? He is with him.
No, I don't think the other side is there on the online also.
Other side is there?
No, we don't find him. We don't find.
Other side कोई है ये matter में?
Other side is Mr. Probal Mukherjee. I don't.
Yes, Mr. Probal Mukherjee and Mr. Banerjee. Nobody is there. Okay, let it be in the list. Let us tomorrow. Let me see.
Very well.
Very well.
Very well.
Yes, call the matter.
My lord, item number 11, my lord, I'm appearing for the plaintiff. My lord, I was humbly praying, my lord, if your lordship kindly keep it immediately after vacation, because as indicated on the last time, my lord, the settlement process is still going on. If the parties can settle in between, otherwise we shall not.
You are for the plaintiff?
Yes, my lord.
11.
Yes, my lord. Item number 11.
Item number 11. Counsel for the plaintiff submitted. A talk of settlement between the parties is going on. I'm praying for fixing the matter after the ensuing puja vacation. In view of the submission made by the counsel for the plaintiff, case is adjourned. Let the matter appear on 18th November.
My lord, only one thing, my lord, if it can be before 7th, because 7th was the last date when there was an injunction order, it was extended up to 7th of November.
6th of November.
Great.
Yes, next.
Well, my lord, I appear for the respondent, your lordship, the defendant respondent. Lordship, we have served the copy of the written objection. Today I'm handicapped, my lord. My clerk is. I'm so sorry. I'm so sorry.
Because in this matter, the defendant is not appearing. So, my lord, this is my application after presentation of plaint, my lord, for a suit for recovery of money for services provided but unpaid. My lord, here the department has attempted to serve a copy of the plaint together with the documents sued on to the defendant. But your lordship will kindly have a look at, my lord, the report, which is at page 72, my lord. So, my lord, the service could not be successfully completed.
So, what
So, my lord, the
application you filed
department,
now?
yes, this is for substituted service. So, my lord, the department has told us that we must put the email address in our cost title. I do not stand in the way. Of course, by service through email address, it can be done even as a substituted form without amending the plaint. But that is, my lord, under Order 5, Rule 21 also, it is permissible. And now under the Commercial Code, my lord, the rules which has come up, that is also permissible.
So, where is the email? You have mentioned the email.
Yes, my lord, I have. Lordship will kindly see, my lord. Kindly have a look at page 89. First, let me show from the correspondence which I have disclosed with the plaint. Page 89.
Yes.
Lordship will find this email has been received by us from one Shahrukh Khan, whose email address is Shahrukh, then Zainab @hotmail. This is one of the email addresses. And the other email address, my lord, is
Shahrukh Khan.
Shahrukh
underscore
Zainab @hotmail.com. This is one of the email addresses of the defendant. Also countercopied to supermencast, supremeconcast@gmail.com. So this is, my lord, the email address which belongs to that of the defendant. And of course, my lord, we have also disclosed documents in pages 50 to 52, to 52, which shows that this is the email which the defendant has been using from pages 50 to 52.
Same address.
Same email address. Shahrukh Khan and Supreme Concast.
Yes. Where they reside? What is the address?
My lord, it is in Ghaziabad. Now, Ghaziabad, my lord.
So why not through the district judge? Through the
court? Through your lordship can, yes, through the district court. That is, my lord, because this particular defendant is staying another state. That is also very much possible. But, my lord, as an alternative, through email is also possible.
Through email also, but through district judge also.
I leave it to your lordship, my lord, because your lordship will also, my lord, kindly have a look at the agreement where this address is there. The cost title says, my lord, the address is 36 by 37 Ramanuj Dayal Market near MMG Hospital, Ghaziabad. Now, my lord, we have two agreements. Page 39. Kindly have a look at, my lord, page 30.
30 is there, okay.
30 is there, my lord, the address matches. Only the pin code is blank.
Pin code is.
Similarly, my lord, there is one more agreement, which is at page 30, which is at page 40, which also has the same address. So this is the address I had from the document. That is the indenture. Now, my lord, page 45 is a part of that agreement which says, clause number S. The parties agree that parties may correspond with each other over email, and the seller's email ID is such and such. Sellers, we are the sellers, my lord. And the buyer's email ID is supremeconcast@gmail.com and Shahrukh Zainab @hotmail.com. So, my lord, this is the address. Parties agreed that they can exchange correspondence through this address. Now, my lord, because of we attempted service on the regular address, but that failed. That's the reason why, my lord, department has now asked us to incorporate the email address in the cost title. I have proposed that amendment at page 90. This is my proposed amendment.
90?
Amendment 90.
The amendment application.
Yes, because the department told us to amend. My lord, to be very frank, my lord, if this is embodied in the plaint, then I will not have any difficulty even till execution.
Correct.
So let the email address be there. I have taken instruction from my client. Even we also told our client that let this amendment be allowed, and we will ask the department to serve it to the through email. That is possible under Order 5, Rule 21. I'll show that to your lordship. But this is my amendment, Milord. Now, if your lordship, Milord, kindly have a look at Order 5, Rule 21, because that directly deals with service of plaint. Placement. A summons may be sent by the court by which it is issued, whether within or without the state, either by one of its officers or by post or by such courier service as may be approved by the High Court, by fax message or by electronic mail service, or by any other means as may be provided by the rules made by the High Court to any court not being the High Court having jurisdiction in the place where the defendant resides. Now, other than the Order 5, Rule 21, now, Milord, we also have the rules.
That's why I'm asking. Rule.
Lordship will kindly have a, Milord, kindly comes to page 8. Service by electronic mail service or short message service or other electronic mode as may be available.
Yeah.
So, Milord, the procedure is given, Milord, where parties desire. I'm not placing, Milord, Lordship has seen this. It's there. Chapter 4, Rule 70.
Plus 3.
Yes.
Yes.
So, Milord, it has been. So, Milord, my twofold prayer is, Milord, your Lordship will kindly allow the amendment, and upon us, Milord, conducting the amendment, upon the department completing the procedure of amendment, the department be further directed to cause service of the plaint along with documents sued on to the defendant through this particular email address. 2 email addresses are provided.
The plaintiff has filed the present application, praying for amendment in the plaint only with regard.
Milord, I'm sorry to interject. Milord, kindly have a look at page 72. It has already been served through the district session and court Ghaziabad.
Where it is?
Lordship inquired. Page 72.
What has happened?
This service was through the
what has happened to
Milord,
the
it has come back, Milord, the same thing. Lordship, this is the first document I showed you, Lordship. It could not be served, returned back. First 2 sentences, the detail regarding service of.
Thank you.
No,
Plaintiff has filed the present application praying for amendment in the plaint only with regard to addition of the email address of the defendant. Dependent or defendants? The defendant in the cost title as proposed in the proposed amendment appearing at page number 90 of the present application. Counsel for the plaintiff submit that after filing of the suit, the plaintiff has taken appropriate steps for issuance of writ of summons upon the defendant. But the plaintiff has received the report from the Deputy Sheriff of Calcutta of this court dated 21st of August 2025, wherein it reveals that through the process server, through the London district and through the process server of the London district and sessions court as Ghaziabad, attempt to serve the writ of summons upon the defendant, but the same could not be served with the reason that the office could not be traced out, and the people present there told that there is no shop and any person with this name, with this name, full stop. The Posters, the service of the plaintiff has also tried to serve the writ of summons through postal service, but delivery confirmed.
Confirmed back to the sender.
Okay, but the same was also not been served upon the defendant and was returned back to the sender. Returned back to the sender. Full stop. Concept was the plaintiff draw the attention of this court to the provisions of order 5 rule 21 of the code of civil procedure and submit that the writ of summons can be served upon the defendant through the email address of the defendant. The plaintiff has also, the counsel for the plaintiff has also draw the attention of this court to the High Court at Calcutta Commercial Courts Practice Direction 2001 with regard to the Rule 17 within bracket within bracket 3 of क्या बोला draw the attention of this so and so of chapter 4 rule 17 within bracket 3 of this said direction and submit that as per this said direction also the writ of summons can be served upon the defendant through the email address of the defendant. The plaintiff is also draw the attention of this court to the pleadings made in the plaint at paragraph.
Pleading, I showed you, Lordship, the agreement.
No.
Yes,
No.
that is two agreements, both dated 15th January 2024.
Attention of this court to the agreements entered between the parties, wherein it is mentioned that the
page 45, your Lordship can have
address of the email address of the defendant is Supreme SUPREME Concast CON एक ही वर्ड होगा ये देखो page 45 Supreme Concast @gmail.com and Shahrukh SHAHRUKH _ Zenab ZENAB @hotmail.com. Consider the submission made by the counsel for the plaintiff peruse the order 5 rule 21 of the code of civil procedure as well as chapter 4 rule 17 within bracket 3 of the High Court Calcutta Commercial Court Practice Direction 2021. This court find that in the agreement, it was agreed between the parties that the correspondence can be made between the parties through the email address, and email address has been provided in the agreement. It is also found that the document which the plaintiff has relied upon in the suit, several correspondence have been made between the parties with regard to the said email. Thus, this court is of the view that the plaintiff may be allowed, this court is of the view, if the plaintiff is allowed to amend the cause title of the plaint as proposed,
page 19,
proposed in the proposed amendment appearing at page 90, none of the parties will be prejudiced and the same will not change the nature and character of the suit. Accordingly, department is directed to make necessary amendment by incorporating the email address of the defendant in the cause title of the plaint as proposed by the plaintiff at page 90 of the present application within a period of 2 weeks after the ensuing puja vacation. Full stop. After the amendment,
leave to re-verify and
after the amendment is carried out by the department, comma, the plaintiff is given liberty to re-verify and reaffirm the affidavit of the plaint within a week thereafter. The plaintiff is directed after the completion of the process of the amendment, comma, the plaintiff is directed to take appropriate steps for issuance of the writ of summons
Lord, I have made the prayer D.
upon the defendant.
If prayer D is allowed, Lord, because I do not have to take any steps, Lord. It's the department which has to.
But writ of summons, you have to give the first writ of summons.
That I have already given. It has returned back.
Okay.
So that's why prayer
After
D.
the amendment is carried out, after the amendment is carried out, the department is directed to take appropriate step for service of writ of for service of writ of summons upon the defendant through the email address. Email address. Okay. DA number so dispose. Next.
My lord, I appear on behalf of the plaintiff
Yes.
on this unusual day, my lord, where this is one day, my lord, where both the council and the court is handicapped.
Yes.
Very rare occasion, my lord. So I'll not trouble your lordship much, my lord. There is a subsisting interim order which expires today.
Wait
And
for the other side.
my lord, despite directions they had appeared, despite directions they have not filed their affidavits.
Acha, that one. Madhusud.
Yes. So your lordship can record that and kindly extend the interim order, which is there till today.
Counsel for the plaintiff prays for extension of interim order. Accordingly, interim order is extended till 13th of November 2025 or until further order, whichever is earlier. Let the matter appear on 13th November.
Gratefully.
My lord, I appear for the respondent. My lord, we have filed our...
My lord, I appear for the plaintiff again.
Yes, my lord. We have
Also,
served
there is
the written objection upon the plaintiff, your lordship. My lord, I'm handicapped because, my lord, the caretaker of my High Court chamber is not there. I'm not being able to hand over the hard copy before.
Yes, sir. Have you received the affidavit? Mr. Bose?
Yes, my lord, we have received the affidavit.
Yes. So
I
you will
think
file reply?
Yes, my lord, we kindly give us an extension of time to file reply and kindly extend the interim order, my lord. The interim order is also till today.
Yes.
That your lordship will find in your lordship's order of 21st August.
You are not filed the affidavit in court.
My lord, I will. My lord, I'm handicapped because my
So,
caretaker...
my lord, unless the affidavit, your lordship can make a note that I think she has served on my advocate on record.
Yes, my lord. Man, it was affirmed on 11th of September, and my lord,
Have you served it, madam? Have you served on my advocate on record?
13, I have served it, sir.
13th, yes, out.
Very well. Lord. Then kindly give us an extension of time to use a reply.
For the defendant submitted, her affidavit is ready, but due to the circumstance, could not be filed today. But if she will file the affidavit by Friday in the department, the further submitted, the affidavit has already been served to the advocate on record of the plaintiff. Counsel for the plaintiff prays for time to file affidavit in reply. Let affidavit in reply be filed within a week after puja vacation. Counsel for the plaintiff prays for extension of the interim order. The interim order is extended. Let the matter appear on and extended till 2025 or until further order, whichever is earlier. Let the matter appear on 14th November.
Grateful to your lordship, deeply obliged.
Obliged, madam.
Not today.
My lord, I appear for the plaintiff in this matter. My lord, this is my injunction application. The other side is not here. We have already started.
Item 16.
Yes, madam.
Yes.
This is my injunction application. I've already served upon them on the last occasion. Affidavit of service has already been filed. My lord, this is a transaction between two parties relating.
Where is the affidavit of service?
I've already filed, my lord.
But today,
What? It is running in the list, my lord.
come
Every day.
tomorrow?
Yeah, yeah,
Not
yeah.
today.
My lord, one humble prayer more, my lord. There is an contempt application which is supposed to be appearing tomorrow, and the contemptor number 2 is already here to surrender before the sheriff, and the sheriff is not present here today. So that is the reason, my lord.
Come tomorrow.
My lord, he is going to leave because there's only difficulty is contempt number 4 is mandatory to be present tomorrow because of lordship's order, and he has an ailing mother. If he comes tomorrow, then he needs to be there. That is the reason he has traveled today to surrender himself.
Where from he come?
Chennai. That is the reason.
Not
I've already given the letter to sheriff to surrender.
But sheriff is nobody is there.
But yes, from sheriff office instruction is there, my lord. I've already got the instruction.
Yes. No, sheriff office में कोई है?
Yes, yes, my lord. He's
क्या करेगा कब वो फाइल कहीं यहाँ है? Jairam Chaudhary.
his son is here. Jairam Chaudhary himself will come tomorrow because of lordship deduction because of 5 lakhs he has to pay.
What is his name?
Krishna Kalyam. Krishna Kalyam Kumar.
Huh?
Krishna Kalyam Kumar.
Oh, no, this is a serious issue.
His father is here who is to run the business. He is going to come tomorrow. The only problem is that his son, if he doesn't travel back today, my lord, there is a difficulty that he won't be again able to come tomorrow.
Come tomorrow.
Because my lord, he needs to take care of his mother there. He is traveling tomorrow because of lordship order.
He was there only.
Who? He on the last occasion he was here, and because of lordship direction, he will again be there tomorrow.
He has to present on
Yes,
each and
he will be present all throughout. But I am only praying for an exception for the son because he needs to take care of
But
the.
they are very careless. Earlier also he has given the undertaking, but nobody is appearing. And
I understand, my lord. That is the reason he has
every
paid
time
the
warrant
hefty
is to
bond,
be
my lord.
issued. Then the report is to be called from the SP and officer in charge. Then they used to come, and that was only.
I understand, my lord. I understand. This is everything is whatever done. My lord. That tomorrow the investor is also coming in front. Virtually, he will appear, and I'll file the affidavit. Who is going to purchase the property for 4.5 crore?
I don't know what will happen. What is his name?
Krishna Kalyan Kumar.
Krishna Kalyan.
Yes, my lord.
Krishna Kalyan.
Krishna Kalyan Kumar.
Kumar. Is that a different?
Contempt number 2.
So 1, 2, and 4.
1, 2, and 4, my lord. 1 can't come. That she's bedridden. That is the reason he needs to take care of her.
You persons are taking so risky. Your father is taking so risky before this court.
His father is going to come tomorrow because he has already given a bond of 5 lakhs.
The alleged contemptor number. The against the warrant issued by this court, the contemptor number 2.
2
is the 2, namely Krishna Kalyan Kumar, is surrendered before the sheriff of this court, deputy sheriff of this court, and accordingly the report is filed before this court. Accordingly, the same was informed to this court. Counsel for the alleged contemptor submits that the contemptor number 1.
Contempt
number 1 is father.
The mother.
Is contempt number 1 is the mother of the contempt number 2, and contempt number 4 is the father of the contempt number 2. Contempt number 1 is totally bedridden, and the contempt number 2 is taking care of his mother. We submit that in terms of the order passed by this court dated 18th of September 2025, the contender number 4 is to appear before this court in person tomorrow. And if the content number 4 will appear before this court tomorrow, then the content number 2 is to be remain present with the alleged content number 1, who is totally bedridden. Accordingly, he has surrendered before this court and submits that as and when required by this court, he will appear before this court. Consider the submission made by the counsel for the alleged content number 2. This court find that the alleged content number 4 is already appearing tomorrow before this court, and the content number 2 is taking care of his ailing mother, who is a bedridden. Thus, the content number 2 is released on the personal bond of rupees 1 lakh.
My lord, kindly little less, my lord, because already the father has given 5 lakhs, my lord. He's
Personal bond of rupees in failure. Bond of rupees 1
my lord,
lakh.
that much
1
amount
lakh.
need to be there enough.
And with the direction that as and when required by this court, the content number 2 shall appear before this court in person. It is made clear that if a direction is passed for appearance of the content number 2 and the content number 2 fail to appear before this court, the content number 2 shall be liable to pay to deposit the surety amount of rupees 1 lakh before the registrar or original site of this court. Full stop. For the time being, the warrant against the alleged content number 2 is kept in abeyance.
Grateful,
Let
my
the
lord.
matter appear tomorrow. Italy number. Yeah?
Grateful, my lord.
The item number 15 was not called.
15 कॉल हुआ कौन appear हुआ? Yes, when the 15 was called, nobody's appeared.
Oh, I'm sorry, my lord. We couldn't hear the lordship's office. My lord, may I only make this request? My lord, this is that Mani Piramal matter which I mentioned yesterday before rising.
Yes.
Well, if it can be kept, my lord, sometime in the first half tomorrow, it's 10 minutes, my lord. Either your lordship will pass an order.
Not today, let it come tomorrow, not today.
Very well.
I am not passing any, let it come tomorrow as on
Very
the
well. Very well.
Not today.
My lord, item number 18, I appear, my lord, for the plaintiff. My lord, this is that order 13A application, my lord, which lordship was hearing. I had, my lord, Mr. Rachit Lakmani had concluded his arguments on behalf of the defendant. This arises out of a fee-con agreement. It will come back to your lordship's mind, my lord, where, my lord, I was entitled to some charges, my lord, for getting a tenant, which was Kalyan Jewellers
Got
for
it.
the defendant. So if lordship permits, my lord, I can conclude, my lord, my reply.
Kalyan Jewellers.
Yes, my lord. Yes, my lord.
Yes.
My lord, the other side is here. If lordship permits, I can, my lord. I'll not take much time, my lord. My lord, may I start, my lord?
Yes.
Yes. My lord, Mr. Lakmani has broadly, my lord, taken 2 points. My lord, he says that there are triable issues and this matter should be relegated to, my lord, trial. And the triable issues as he had framed were twofold. My lord, the first triable issue according to Mr. Lakmani was this, that if the agreement, the lease between the defendant and Kalyan Jewellers did not fructify, can any brokerage be paid or demanded? That was the first triable issue according to Mr. Lakmani. The second, my lord, triable issue was the settlement agreement was not signed or not executed by the defendant, but Mr. Murarka, who was one of the directors of the defendant. And therefore, the company did not admit any liability. This was, according to him, the second triable issue. My lord, no written statement in this suit has been filed. So, my lord, if trial had to occur, then, my lord, the defendant would only have the right to cross-examine the witness of the plaintiff only to the extent of demolishing the plaint case. So, the defendant cannot suggest a case, which is because there's no written statement.
Correct.
So, my lord, apropos this, Lordship will first come to the fee-con agreement, which is at page 71 of the petition. This is to demolish his first, my lord, understanding of the triable issue, that if the agreement does not fructify, brokerage cannot be paid. Kindly comes to page 71, my lord.
Yeah.
This document is telltale, and after this document, there is nothing that is required to be tried. Well, it's a document of 31st of December 2017, addressed to the defendant through its director Vikas Murarka. Subject is fee-con and revenue recognition confirmation. This letter serves as the fee-con and revenue recognition confirmation between Jones Lang LaSalle and BP Suraj, the two parties. This is to confirm that JLL service are satisfactorily completed. My lord, kindly marks the expression confirm. That JLL services are satisfactorily completed upon signing of agreement for the transaction of Kalyan Jewellers at Bowbazar, Kolkata, as on 26 December 2017. JLL is eligible to raise the invoice for the amount mentioned below. My lord, the amount is monthly rental is 23 lakhs for the area, and the transaction fee, I was entitled to 2 months rent. So the transaction fee was multiplied into 246 lakhs plus the taxes. Total transaction fees for Kalyan Jewellers transaction at so-and-so is INR 46 lakhs plus applicable tax representing full and complete amount due to JLL and is payable upon receipt of invoice.
Yes.
My lord, nowhere does it say that till such time the agreement is fructified between the defendant and Kalyan Jewellers, no payment can be made.
Yes.
And my lord, kindly sees the last paragraph. You hereby confirm that the agreements are confidential since you will not be able to share the copies. However, you have provided us with the signed LOI copy for reference. Signed by, my lord, the executive of the plaintiff and the executive of the defendant as a token of acceptance. So there is a confirmation, there is an acknowledgement, there is a acceptance. And it says that only upon the transaction being complete,
yes,
and the signing of the agreement, that I would be entitled to raise an invoice for this money. Now, my lord, two documents that the, my lord, agreement was signed between the parties. Lordship kindly takes, my lord, the lease deed, which is at page 56.
yes,
Kindly takes note of the names of the two parties: BP Suraj Business Combined Private Limited, that is the defendant in this suit.
yes,
and page 57, Kalyan Jewellers India Limited.
yes,
And it's signed on each page, my lord.
yes,
So I satisfy the condition which is there in page 71 that my services were complete upon signing of the agreement.
yes,
Therefore, my lord, my first submission that the triable issue, as was, my lord, framed by Mr. Lakmani, that if the agreement does not fructify, brokerage cannot be paid. My lord, this cannot be a triable issue any longer by reason of the documents at page 71 and the lease deed, which is at page 56, having been executed by the two parties.
yes,
My lord, the next, my lord, argument which he makes is that the settlement agreement
yes,
was not signed by the defendant company. It was signed by a director of the defendant company and therefore not binding on the defendant company. My lord, this again, my lord, to demolish this argument also, kindly comes back to, my lord, the settlement agreement once at page 197, volume 2. (197), my lord.
yes.
kindly takes the names of the parties, my lord, at 197. It
Yes.
is not Mr. Murarka, but BP Suraj Business Combines Private Limited.
Yes.
In short, referred to as BP Suraj of the first part. And the second part is my client, the plaintiff, Jones Lang LaSalle, which is JLL in short.
Yeah.
Well, it kind of comes to page 198, the recital D at the top of that page, 198.
Yes.
Subsequent thereto, in fact, Lordship had put a question to Mr. Lakmani by drawing his attention to this particular recital, that it is not Mr. Murarka, but it is referred as first party.
Yes.
And that's my submission in reply, my lord. Subsequent thereto, the first party through Mr. Vikas Murarka, being one of the directors of VP Suraj, approached JLL for payment of rupees 31,28,000. Now, their understanding was very clear that it was the defendant who was agreeing to have the issue settled by making payment of a sum lesser than what was demanded or lesser than what I was entitled to under the FECON agreement.
Yes.
Because we had gone to NCLT, because there was an order of admission, suddenly they realized that it's now urgent to have this issue settled. So they agreed to the settlement agreement that we will pay you 31,28,000, and it is the first party who is the company, the defendant company herein, who has agreed to, my lord, pay. Not only that, my lord, I realized or I received part payment of this 31,28, not from Mr. Murarka, but from the company. The defendant company paid this amount.
Yes. Yes.
My lord, kindly at this juncture, my lord, once take the affidavit in opposition filed by the, my lord, defendant, paragraph 1, because they are now trying to, my lord, say that this gentleman, Mr. Murarka, possibly did not have authority.
Yes, that is a ground they have taken. He is not the authority, and why he has signed.
Now, my lord, kindly takes, my lord, the affidavit in opposition filed.
Yes.
I'm sorry, this is, my lord, filed before the, it's not in the opposition, it's there in the, my lord, petition itself. Mr. Sen, can you give me the page number?
Page 165, volume 2.
My lord, kindly volume 2, page 165. This is the affidavit in opposition filed by the defendant company in the NCLT proceedings. It starts at 164, kindly comes to, my lord, 165. Reply affidavit on behalf of the corporate debtor.
Of affidavit in opposition?
No, my lord, I'm sorry, my lord. It is, my lord, the petition volume 2, my lord. I stand corrected, my lord. It's the petition volume 2, page 164.
Yes.
My lord, this is the reply affidavit filed by the defendant company in the NCLT proceedings. Kindly come to 165. Kindly seize, my lord, who has affirmed this affidavit. I, Vikas Murarka, my lord, the same person, son of so-and-so. Then the first paragraph. I am the director of the corporate debtor herein, and as such, I am well acquainted with the facts and circumstances of the case. I am competent to affirm this affidavit by virtue of a board resolution of the company. So it is the company who authorizes Mr. Murarka to file the reply affidavit in the NCLT proceedings.
Yes.
And Mr. Murarka files the reply affidavit and thereafter enters into the settlement agreement.
Yes.
On behalf of the company, by which, my lord, they agreed to pay a sum lesser than what I was originally entitled to under the, my lord, FECON agreement. So in my respectful submission, my lord, the second triable issue, which Mr. Lakmani tried to frame, that whether the settlement agreement was signed by Mr. Murarka in the capacity of a director would bind the company or not, that is also not, my lord, borne out from the records.
Yes.
It is really, my lord, the company authorizing Mr. Murarka to do all this. He files the reply affidavit, he signs the settlement agreement, and it is the company who honors the obligation recorded in the settlement agreement by making part payment.
Yes.
So neither, my lord, this can be said to be a plausible nor a probable defense of the defendant.
Yes.
Now, my lord, under the agreement, under the original agreement, I was entitled to 46 lakhs being 2 months, my lord, rental along with applicable, my lord, taxes. Now, I compromised on that figure and agreed to take a lesser figure, my lord, with the hope that I would realize that money within the, my lord, time frame which was provided for in the settlement agreement. But in default, I am entitled to, my lord, the entire money. That is, my lord, there in the settlement agreement. And I, my lord, today, in terms of, my lord, their email acknowledgements, my lord, I say I am entitled to the entire money as a summary decree. My lord, I'll just refer to the emails by which they had confirmed this. I had shown this, my lord, to your lordship when I started, my lord, my opening submissions, but just for a, my lord, quick recapitulation, my lord, kindly takes Mr. Sen the email. Page 81, my lord, kindly comes.
Yes.
My lord, these emails are exchanged after, my lord, we raised our invoice for 46 lakhs and the taxes, my lord.
Yes.
He takes the foot of the page at 81.
Yes.
We will settle and pay by December only. We never issue PDC. Please cooperate. My lord has got that, my lord?
Yes, yes, yes.
Possibly it will be marked in your lordship's brief.
Yes.
Humble request to you, please keep patience as you have been and given us some time. Finally, we will give your total payment done as early as possible. Kindly marks this, my lord. We are committed for the same. My lord, after all this, my lord, how can even there be, my lord, any argument advanced by the defendant, particularly when they chose not even to file a written statement in this matter?
Yes.
Please manage your scenario, which will not be a good place because of us. We know very well that you were relying on this and you will be facing trouble because of not getting fund. We know due to this situation, we will not be.
That's all.
Yes, my lord, just the mail above that, my lord, same page. We want to inform you that I'm already committed to you that I will release and settle your bill by December 2018.
Yes.
Thereafter, I again request you, please keep patience. Very soon, we will call you regarding your payment. My lord, this, my lord, payment which they are talking about is on the basis of the invoice, which is at page 72. My lord, this is the last document I referred to, my lord.
Yes.
Because this was, my lord, the entitlement of the plaintiff under the, my lord, FECON agreement. 2 months, my lord, rental, which is 46 lakhs, plus the tax component, it comes to, my lord, 54,28,000. I have realized, my lord, only 10 lakhs in terms of the settlement agreement. I am entitled to the balance sum, my lord, together with interest component. My lord, considering it's a commercial matter, I leave it to my lord's wisdom, whatever interest lordship will provide. We have claimed, my lord, in the plaint, interest at a particular rate. My lord, that is, my lord, at page 32, lordship will find the figure which I have claimed in the plaint, and paragraph 26.
12%.
12%, my lord, which is at page 31.
Yes.
These are my submissions, my lord. So, my lord, out of 54,28, if we deduct 10 lakhs, my lord, 44,28 is on account of 44,28,000 is on account of principal, plus, my lord, interest of 12%. That is what we have claimed. So, well, I was praying, my lord, the application be allowed and a decree in summary form by invoking the provisions of Order 13A, my lord, be passed without, my lord, relegating this matter to trial, because there's nothing, my lord, required. My lord, no trial is required, my lord, as no tribal issues have been, my lord, pointed out by the defendant. And there cannot be any, my lord, tribal issues in this matter.
Yes.
Those are my respectful submissions, my lord. Since we are, my lord, appearing online, please permit, my lord, me to just inquire from Mr. Sen, just in case I have missed out on anything. Mr. Sen, if I have missed out on anything, you can add.
My lord, with leave of Mr. Datta, my lord, only one point, my lord. a submission was made, my lord, on the last occasion that, my lord, the NCLT order, my lord, disposing of the proceeding does not record, my lord, that it is being disposed of pursuant to the settlement, my lord. That is possibly not a correct submission, my lord, because my lord would recall, my lord, Mr. Datto had placed, my lord, a specific clause from the settlement agreement, my lord, that the insolvency resolution professionals' dues and fees, my lord, would be paid by the defendant, my lord, pursuant to the settlement agreement. The order, my lord, would have a look, my lord, at the NCLT order, my lord, records that, my lord, the fees of the IRP, my lord, have been paid, and accordingly, my lord, the proceeding is being disposed of, my lord. So it is incorrect, my lord, to suggest that the NCLT does not take note of the settlement between the parties, my lord. But those are my respectful submissions, my lord. I'm deeply obliged.
We are very grateful, my lord, for a very patient hearing.
Very grateful.
Hearing concluded, CAV, in connection with GACOM 2 of 2025.
Grateful, my lord.
I'm deeply obliged.
But only one thing, I'm sorry for leave to mention a matter. There's a matter fixed at 3:45, which is for witness action, for judgment daters to come in.
I am the decree holder. These are three matters.
Yes, item number 6, 7, and 8.
I'm vehemently opposing Mr. Mitro's request, my lord. His client should have been present in this inclement weather.
The only thing,
I would only request, my lord, let it be in the list if it can be taken up tomorrow. These are three judgment debtors, my lord, and it will come back to your lordship that these judgment debtors, my lord, at least they have filed 3 affidavit of assets after making repeated mistakes. So this is the only issue. If it can be kept in your lordship's list, my lord, we would be attending. I leave it to Mr. Mitro, my lord. I'm sure that
tomorrow they can come. Subject to the weather, they can come tomorrow.
I will not take. If the parties are not there, then it will not be taken.
Yes.
But tomorrow the time won't be fixed, man. That is the only difficulty.
No time.
No time. It will be there. I know. That's
the list.
I'm obliged.
Your lordship.
Obliged, deeply obliged.
Item number 51 of today's list, your lordship. Your lordship has directed to file us. I'm appearing for the plaintiff in this matter, your lordship. Item number 51, your lordship. Your lordship has directed to file the suggested issues, your lordship, on 22nd of this month, your lordship. I had come to the court offices, your lordship, yesterday at 4:30 p.m.
Okay, have you served the copy to the other side?
Lordship, I will serve.
Serve, take the note, then come on the date fix. You
Lordship,
serve the
today
copy.
is the date fixed, your lordship.
Today is the date fix.
Lordship.
Which month? 51.
Item number 51.
But
Lordship.
Framing of the other side is not here. Keep that on. Come on the next.
couldn't impress upon your lordship the urgency. Well, this is the matter where I'm led by Mr. Anuj Singh. Well, properties have been sold which were never of the company under liquidation. Now, the official liquidator has already given a report from where it is clear that it has not been sold. Now we get an information that these properties which have been sold, we are the original owners. Our property which never belonged to the company has been sold. They are now, Milord, being sold to other third parties. Now, I believe, Milord, that we will be in a position to take only 10 to 15 minutes of your lordship's valuable time.
But
If
my,
it
that's
can be
been told.
accommodated.
Already my matters are fixed in the company. 2 also, 3 also.
But anytime up the list, that would be sufficient.
That's what I'm telling. Let it be in the remainder list.
Yes, but
It
yes,
will
let
be in
it
the,
be. Let it be.
instead,
I'm not.
it is in the list.
I am not asking for fixation of any time.
Okay, it is
I
in
am
the
only
list.
saying if it can be upgraded, then it may.
Upgraded cannot be. Let it in the list. Let me see what how.
Yes,
far
if your
the
lordship can
process.
kindly consider, may I kindly
Proceed
Milord,
with-
hand up?
No, come tomorrow. Come tomorrow.
But if it can be upgraded, at least.
No, upgraded how? We got 2 p.m., 3 p.m., 3:30, and you will tomorrow is the Wednesday. Then naturally you will take.
No, that's why the difficulty.
All the advocates will be busy today, so tomorrow there will be a resolution.
No, I only express my difficulty to your lordship.
That's
I leave it to your lordship. Kindly allow me to
Let
rest
it
it
be
with the-
remain in the list. Then you mention if it time permit, I will take.
Oh, very fine. This assurance is sufficient.
Okay.
My lord, with due respect, my lord, item number 3, we fixed at 2 p.m.
Yes.
My lord, I am for the defendant. My lordship may remember Mr. Mitro yesterday mentioned this matter. And he was requesting for fixation of date after vacation, my lord. Lordship was directed to be mention this matter when the matter is called on. Since the today's situation, my lord, I think
So the
no
matter
one is appealing.
fixed today at 2 p.m. But due to some unavoidable circumstances, matter could not be taken up for hearing. According cases adjourned, let the matter appear on 2nd December at 3:45 p.m.
My lord,
3:45.
3:45, my lord.
Yes. Yes, next.
Careful, my lord.
Lord, has your lordship called item 19?
Item number 4. Change. Why are you not changing? Yes, 4 nowadays. Not today. Next.
Number 19.
My lord, in 19, I appear for the plaintiff, my lord. My lord, if your lordship takes your lordship's order of August 11, 2025, my lord, there were directions for discovery inspection. This was the third, in fact, third direction for discovery inspection. We had offered them to the defendant had not taken it. Eventually, your lordship passed this order. My lord, thereafter we offered again. They did not take. 5 days prior to the relisting of the matter, my lord, they said that they are ready and willing to take, my lord. All I say, my lord, for the interest of justice, if your lordship deems it fit and appropriate, my lord, the directions may be extended for a further period if they want to complete the discovery inspection, my lord. We are the plaintiffs, my lord. We are ready and willing to proceed with this.
Yes. So in discovery, not have you disclosed the document?
My lord, we on August 14, my lord, my learned junior is carrying the email. On August 14, 2025, immediately after this order, my lord, we had written to them asking them to take discovery inspection of our documents, my lord. There was a silence from their end. Nothing was done. Then they issued an email on September 11th, if I'm correct, my lord, saying that they are ready and willing to disclose. Then, my lord, the disclosure hasn't happened. My lord, I was praying, my lord, extends, if your lordship extends the time for, my lord, after the puja vacation, my lord, we'll complete this and come before your lordship.
Counsel for the plaintiff submit that. In terms of the order dated 11th August 2025, the plaintiff has plaintiff by an email dated 14th of August 2025 informed the defendant that the document is ready for inspection. But in spite of the receipt of the said email, the defendant has not informed the plaintiff with regard to the inspection of the document. All of a sudden, on 11th of September 2025, the defendant has informed the plaintiff that the defendant is ready and willing to take inspection of the document. In view of the above, time to complete the discovery and inspection of the document by both the parties is extended for a further period of 2 weeks from after the puja vacation. The parties are also directed to file their affidavit of admission and denial of the document within a week thereafter. In the meantime, the parties are also directed to exchange the suggested issues. List the matter. 2 week, 1 week bola na. List the matter on 26th of November 2025 for framing of issues. It is made clear that this order is preemptory in nature and no further time shall be granted for inspection and discovery and inspection of the document and filing of affidavit of admission and document. And without the inspection of the document, the issue will be framed and the suit will be proceeded.
Deeply. My lord, there are 2 GA applications also appearing, my lord. They are filed by the defendant.
On the said date, the connected applications may also be listed for hearing.
Deeply obliged.
Next.
My lord, item number 20, my lord, this is the substitution application, my lord, which has been pending, my lord, since, my lord, forever. But Mr. Bose was to, my lord, make his submissions, my lord. I really do not know, my lord. I saw Mr. Bose, my lord, making submissions in the, my lord, first half. My lord, I do not know whether he'll be, my lord, continuing with his submissions today.
है कोई है नहीं है बॉस है ऑनलाइन मिस्टर माइनर बॉस
Because, my lord, it is my application, hence, my lord, the predicament of, my lord, losing out time, my lord.
Not today. Not today.
Very well. Very well.
Your Lordship, I'm appearing on behalf of the plaintiff. My seniors are actually not are unable to come.
Not today.
Not. And item number 22 is also mine.
Not today.
Thank you.
My Lord, 23, Your Lordship remembers
Item number 23.
Mr.
I
Shuman
appear
Dottu
for
was
the
making
plaintiff.
submission. Mr. Shuman Dottu was making submission, my Lord. I am for the respondent number 1. My application for disclosure of the documents were being considered by Your Lordship. Now, Your Lordship was last occasion, my Lord, directed us to file an affidavit disclosing copies of the document which we intend to disclose. My Lord, that affidavit has been affirmed, has also been served to my learned friend, my Lord. I believe we have filed a copy in the department also. But today, due to this situation, my lord, if the hearing can be taken up some other day.
My lord, I appear on behalf of the defendant number 2, my lord. So far as my client is concerned, my lordship has already clarified by a previous order that since the documents which we wanted to rely upon are common documents disclosed by the plaintiff.
Yes, I think that has been permitted by court.
That has been sorted out. So far as this application is concerned, my lord, I have nothing to say. It's between the plaintiff and the defendant number 1, my lord. I am not standing in the way, my lord. Whatever way lordship decides, my lord.
Yes, Mr. Ghosh.
So can it stand over till post vacations? I don't think there's any urgency.
My lord, I was also praying the same thing because this will take some time, my lord.
The matter appear on 11th November 2025.
Grateful, my lord.
Grateful.
Grateful, my lord.
Not today. Item 25. Not today. Item 26. Yes, in any other matter, parties are appearing.
Lordship, I am appearing for the plaintiff, Lordship. The matter can be taken up after vacation, Lordship.
After vacation, who is for the defendant?
Defendant maybe.
But I appear for Mulad. Both Mr. Jain and Mr. Mulad Banerjee is Mulad opposing me, Mulad, in this Mulad. I believe Mulad in item number 28, Mr. Banerjee is appearing, and in item number 32, I believe Mr. Jain is appearing.
28, I can argue and complete it. Mr. Sarkar has already made his submissions.
Yes.
Application in my suit for rejection of plaint on the ground that it is not a commercial dispute. Your Lordship permits me, I can. I'll take
item number
5 minutes time.
28.
28.
But I have to give reply, my lord. If your lordship, my lord, kindly, my lord, permits me to, my lord, then, my lord, take it up, my lord, tomorrow.
Then I will also make submission. In that case, I will also make submission tomorrow. I was thinking that it can be completed because it's a very small conspectus. It's only the plaint which has to be gone into. Mr. Shorkar has made his submissions. He has also relied on
Okay,
judgment.
not today. All matter will come tomorrow.
Tomorrow becomes a Himalayan day.
It will be, my lord. It will be. I understand, my lord. It will be.
As you
If today's night is not repeated.
Oh, yes, of course. It was a terrible night. It was a terrible night. My lord, so far as Mr. Jain's application is concerned, my lord, I am opposing. My lord, it's his application for, my lord.
Let it go to after vacation.
Lordship,
Very
if
well.
time can be fixed, Lordship. If a date and time can
Then
be
December. Time you want December.
Lordship,
No,
there has been a change in the advocate and record and
correct, no problem. But my dad,
delay in that application.
item number 30 record karo as per the
32.
made by the council
Lordship,
for
I stand corrected, Lordship. Item 32, Lordship.
32.
32, yes, my lord.
32. As per the prayer made by the council for the plaintiff, case is adjourned. Let the matter give कोई date है या कोई?
I'm grateful, my lord.
At 8th December at 3:45 p.m.
So grateful, Lordship. Deeply obliged.
8th December. Grateful, my lord.
No other matter.
My lord, I was appearing for, in the next matter, the respondent, order 11, my lord, Mr. Jishnu Chaudhary, my lord, had completed his argument, and I was to start my arguments.
Have you got that second copy of the plaint? No.
My lord, I have asked, my lord, them to keep a second copy of the plaint, my lord. But the advocate on record could not reach, my lord. His car is, my lord, underwater, my lord. So he also couldn't reach, my lord.
Okay, thank you.